Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England. Benjamin is an accomplished attorney with extensive experience in FDA regulatory law and international trade compliance. As the founder of FDAImports.com, he provides strategic legal guidance to businesses navigating complex regulatory and trade challenges. I'm your host, Heidi Mack, and today we're diving into FDA import alerts. What gets a business flagged? How can you tell if you're at risk? And if you're already in trouble, is there a way out? This episode is Import Alerts and Red Flags, how to stay off FDA's watch list. Thank you for joining us, Ben. We really appreciate it.
Hi, Heidi. Thanks for having me. I really appreciate the opportunity to talk to the crew.
Thank you. We loved hearing all of your knowledge. So let's get started. Ben, what exactly is an FDA import alert, and how many are there, and what kind of products or industries are covered by them?
All right. So FDA import alerts are essentially guidance documents that FDA headquarters issues, and they issue them to the FDA field personnel. And they're telling the field personnel, these are the companies and their products that we've already had some problems with, and therefore you would be okay if you were to detain them without physically examining them. Usually when something comes into the country, FDA will sample it, or they'll examine it, or they'll look at the label, and they'll determine whether there's a violation. And if they do, then they'll detain it, and then you go through a process in order to obtain release. With an import alert, those early stages are sort of done for the agency. FDA has already come to a conclusion that there's a problem with respect to a particular product from a specific supplier. And there are import alerts for everything FDA regulates. There are import alerts for food items, for cosmetics, drugs, medical devices, tobacco products, really biologics. Everything FDA regulates can be covered by an import alert. I don't know the number of them, but there's over 200. There may be 250 import alerts that FDA currently is responsible for and has issued. And their effect is really dependent upon the kind of problem that there is with the product, whether it's a contamination problem or a labeling problem or a pre-approval problem. But that's sort of like a large overview about what these import alerts are.
So then what's the difference between being flagged for detention and being placed on detention without physical examination?
So FDA detains products, as I mentioned a moment ago, usually based upon sampling or testing. And so that is a sort of one-time event about that particular shipment and that particular product that's coming in. If FDA believes that they now have gained enough evidence about the supply chain or the supplier or the product or the combination of those things, that they believe that there's enough evidence that the next shipment probably is also going to be in violation, then you go onto an import alert. The difference is FDA doesn't waste any resources sampling it or testing it. As soon as it comes in, FDA automatically detains it. So if you're on an import alert, then you know, if your supplier is on an import alert, for instance, your foreign supplier, then you know that every one of those shipments, as they come in, FDA is going to stop it and require you to do something in order to get it released. So it's a big difference, right? On the one hand, it's a one-time event about a particular shipment. In case of the import alerts, it's everything that comes in. It's every time that same product comes from that same supplier. And the import alerts can be quite broad. It can be like all products from a particular facility. That obviously would cover everything that comes in. So it's a much broader impact. It's going to guarantee essentially stop detentions of those products. And as you sort of mentioned the name, detention without physical examination, that's the key. FDA does not physically examine it. They just detain it based upon what it is when it arrives.
Interesting. What then typically gets a company or product added to that list, that import alert list?
It depends upon the problem that FDA is trying to solve. In many cases, FDA will have sampled the product and tested it in some prior shipment, and they found some microbiological contamination like salmonella or E. coli or something like that. In other cases, they may have tested, say, a plant-based product, whether it's canned or fresh vegetables or fruits, and they found pesticides. above a certain tolerance. And so in that case, it would be a pesticide import alert that the product goes on. There are also import alerts based upon FDA inspections, FDA having inspected a facility, or FDA finding certain violations that are indicative of there being a problem in the facility. An example with that would be a Staphylococcus aureus in a particular microbe in certain cheeses. If it's above a certain number of microbes, like literally to count, then FDA assumes that the facility is insanitary. So in that case, pretty much everything coming from the facility is going to be stopped. Some cases have to do with approval. The product might require an approval and doesn't have it. Sometimes it's about labeling. So it really depends upon what the product is, the kinds of problems that FDA cares about that particular product, and then the evidence that FDA has on a case-by-case basis.
So, you're giving us some examples there. Are there, out of those examples, or, obviously other things, are there certain industries, product types, countries that seem to be flagged more often than others?
FDA will, well, the flagging ordinarily is going to be based upon primarily the evidence that the agency has. And that evidence might arise from, say, prior examinations and prior samplings. But it also might be based upon some other intelligence that the agency has. And I'll give you an example. When the earthquake that caused that terrible tsunami in Japan, as you might imagine, Japan produces a lot of products that come to the United States. And so in that case, FDA didn't have any particular problem with any particular facility or any evidence about a particular facility, but obviously they had a regional problem. So FDA would place a bulletin or an alert on all products coming from that region because of that kind of problem. So that's an example that's not related to the particular product or facility. Otherwise, FDA tends to focus its sampling and its testing on products of higher risk. So ready-to-eat foods, for instance, something that you open it and you eat it, higher risk. If there's a contamination, there's no kill step. You're not going to cook it before you eat it. Raw shrimp is going to require cooking. Raw tuna might not, right? So FDA is going to look at raw tuna and raw salmon differently than they do shrimp. And they'll consider one potentially ready to eat, whereas the other one they would consider not ready to eat. And so the risk level is going to be higher for the ready to eat foods. I would say that the higher the risk that the product represents is going to increase the likelihood of FDA interaction. When you increase the risk of interaction, you increase the risk of FDA finding a problem, and therefore the risk of going on to an import alert. Some places have problems. There's some. You may be familiar with tamarind. Tamarind is a spice. It's a plant-based root that is used for lots of different reasons. It's used for tea. It's used as an ingredient in drinks and beverages. It also is used in many dietary supplements. It's used in cosmetic industry. FDA has a worldwide import alert on tamarind for filth because it's notably there's a lot of problems a lot of times with filth in tamarind. That's a very, 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 very broad import alert. It probably isn't legal. If FDA were challenged on it, they probably would lose. But it could go from that extreme to one particular type of food coming from one particular facility because the FDA has found a problem with it. So it really can be anything that FDA considers to be violative, but they tend to focus on the highest risk products first.
Wow, that's so interesting. I never thought about tamarind. I have it in my spice rack.
Sure.
Wow,
Sure.
like that's incredible. So like, say, can companies be placed then on an import alert without warning, or is there usually typically some kind of notice that they could see?
Usually a company is placed on import alert because the FDA has sampled and tested their product at the border. And so assuming that the manufacturer is in contact with the importer would ordinarily have informed the manufacturer about the problem, right? FDA sampled and found salmonella, FDA sampled and found some other problem with respect to their product. And so I would expect ordinarily that the foreign supplier would have heard it from the importer, but there is no actual notice that's provided by FDA to the foreign supplier saying we're going to put you on import alert. The one exception to that is if the FDA conducts an inspection of your facility, and you get a warning letter. If FDA is issuing you a warning letter because of the problems they found in your facility, very often they will say in that warning letter, as a result, you'll be placed on an import alert related to good manufacturing practices or some other issue that's relevant to the manufacturing facility. But usually there's no warning or no notice. But it's often not a surprise either. Most of the people in the industries know how it works. And so when they have a particular problem, they start watching the import alert to see if they show up on it, right? So most of the time, industries are pretty familiar with what they're going to confront.
Yeah, I didn't realize that. I worked in food and beverage for a long time, and when they come, they don't tell you they're coming a lot of times when they come to inspect a restaurant. So I was like, oh, I mean, for that, it's a surprise. But then, if they do find something, they usually give them that time, like you said about the notice. I didn't know it worked the exact same way. So I find that very interesting. So once a product is flagged, what does a company have to do to get off that list then?
Well, it depends upon the reason they're flagged. Let's use the more extreme versions. FDA places a company on import alert because the product FDA believes requires an approval and lacks that approval. And in that case, the only way to come off the import alert would be to obtain the approval. Depending upon what the product is, then it could be quite expensive. If it's a drug, then a new drug approval is going to cost millions of dollars. Now, if it turns out that the product is not really supposed to be a drug, but they've got claims on the product that made it a drug, so like a cosmetic or a dietary supplement, and they just went too far in their claims, that can cause the product to be a drug and consequently an unapproved drug because it wouldn't have been an approval for it. In that case, you would get off the alert by showing the FDA why you made the mistake, right? How you fixed it in the future to make sure you don't make that claim anymore. And here's all my new labeling in order to remove the claim. And now it's no longer a drug. If it's no longer a drug, it's no longer an approved drug. That can happen with medical devices. It can happen with cosmetics. It can happen with dietary supplements. It can happen with over-the-counter drugs where the claims go just too far, right? Too far than the regulations allow for over-the-counter drugs. If it's a contamination problem, salmonella, filth, pesticides, then FDA is going to expect you to identify. You have to do a root cause analysis to try to figure out where it came from, and then you do a corrective and preventative action plan, a CAPA, in order to fix it so you don't have future problems. You document all that, and then you export product to the United States. FDA will require your importer to test it. It comes back clean. You get a bunch of clean shipments, and then you petition the agency for removal from the alert. But in all these cases, you're filing a petition. You're communicating with the FDA. For import alerts that are regional, some import alerts are regional, and all of a certain kind of product is automatically detained unless you're on the green list, like you've been exempted. The way you get exempted is also by filing a petition. But it always is about whether and how you have identified and solved the problem that FDA has found. And then you prove that up by having clean shipments. And then after the clean shipments have been released and FDA's done the examinations, then you petition the agency to come off the alert. And we do that work, hundreds of times a year for companies all over the world that export all sorts of FDA regulated products. And each of the alerts, there's a lot of similarities, but each of them are a little bit different, which is why they're on a different alert, right? The part of the agency that cares about it is different. The kinds of problems are different. The kinds of issues that are associated with fixing the problems could be different. And so they're sort of niched out based upon industries and types of problems and types of products.
That's what I was going to ask. You were talking about you have clients that you've already done this. Can you walk us through a real example where your firm successfully helped remove a client from that import alert?
Yeah, I'll give a couple examples. The one sort of like obvious ones are things like seafood that where FDA sampled it and found salmonella. In those cases, salmonella is what I used to be a microbiologist for the FDA before I was an attorney. I used to test food for the FDA, and so I used to test salmonella test shrimp for salmonella all the time. Some countries, it's so prevalent that every shrimp processor is on a countrywide import alert for salmonella, and in those cases they have to get off of the import have to get exempted. And so those cases, you basically show your food safety plan, and then you do clean shipments. You probably have some third-party audits that have been conducted. You present all of that to the FDA, and you obtain the green list status that makes you exempt. Other cases, we've had pesticide cases where it turns out that the farmland that was being used to grow product had been heavily used in industry before it became farmland. So the soil is actually contaminated, and so that the plant's taking it up, and then it's being captured, and then FDA tests it, finds it. It turns out that the farming operation didn't add it at all. It was in the soil. You'll have other situations where I had a client that had product that was on import alert. In fact, it was salmonella, and FDA put them onto an import alert that essentially acts as a ban, because they presumed that there was a major problem in this firm's pasteurization operation. We showed FDA that if there was a contamination, that's separate and apart from whether or not the facility had their process under control. And we presented lots of evidence to show that, in fact, the facility was under control, and they took them off of the alert in that case without any testing at all, because you sort of can't test your way out of a problem that has to do with manufacturing. So those are some examples. We've done it in the drug space and getting companies off the unapproved lists. We've got cosmetics that have been contaminated with, say, illegal colors, or also microbiology contamination. So we've done it sort of all those spaces.
Wow. Well, then, Ben, tell the people what can businesses proactively do to monitor their risk and reduce their chances of being flagged?
Okay, it depends upon who you're talking to, right? If the industry representative is a foreign manufacturer, then they're going to want to have very good standard operating procedures that identifies the kinds of risks that FDA would care about. Those, by the way, are the same kinds of risks that their customers are going to care about and that the consumer is going to care about. And so everybody's sort of in line as the things that they care about. So you need to understand what the risks are, and then have very good SOPs, standard operating procedures, in place to ensure that your operations, the raw materials that are coming into your facility, and that your operations are preventing contaminations or any environmental impact that could come to the product. And then also your claims. You have to make certain that you've evaluated your claims and your labeling, and make sure that's in compliance. And so they're gonna hire somebody to help them do that assessment, and to try to make sure their products are in compliance before they ship them. If they're the importer, if they're on the U.S. side, then they're going to be asking their suppliers for evidence that they've done the things I just said, right? Because the importer, when the goods get here, the importer is the one that FDA is talking to, right? They're the ones that are in front of the agency, not the foreign supplier. So the importer has a real vested interest to make sure that their foreign suppliers are doing things that will not cause the shipments to be stopped, much less the future ones, right? If it's not an import alert, the importer has to pay for private labs to do the testing, and that's a lot more expensive. So it's all going to come down to identifying the risks, having systems in place that ensures that the risks don't arise, and then being able to document that you're doing those things.
And maybe having somebody like you on their side.
Well, that's the thing we do all the time. I prefer, obviously, to have this conversation before someone's on the import alert than after. Because if it's after, their hair is already on fire and everything's expensive and their customers are angry. But it's often the case that people come to me after they have a problem, right? And so we deal with it as they arise.
Well, and that's why you're here. Thank you for your knowledge. So out there, if you've got questions about import alerts or need help clearing your product for entry, don't go at it alone. Connect with Ben and his team at FDAImports.com. And if you found today's episode helpful, don't forget to like, subscribe, and leave us a review. Thank you so much for joining us, Ben. It's been a pleasure.
Thanks, Heidi. Good to see you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.